Hello, everyone. Today we'll discuss what is the minimum estate size for a professional executor. So, what is the minimum estate size before a professional executor will accept and consent to being nominated as your executor? We have a few prospective clients calling and asking recently. So, let's review the situation both for bank executor minimums, our minimums, and some possible exceptions to those minimum amounts. All right, so we'll start with banks. Typically, bank estate minimum sizes are high. We covered this in episode 185, which we'll link below. In New York, it's been as high as 5 million or 2 million liquid held with the institution. And what does that mean? So first of all, when I say 5 million, 2 million, they're usually referring to liquid assets. They don't want to deal with real estate. It's a pain for them. I mean, they will, but they also want to make sure there's enough liquid assets there as part of the situation. But they also want the liquidity held at their bank. So without naming any particular bank, let's say Bank XYZ has a $2 million liquid requirement, but they want that $2 million held with them, invested with them. Obviously, they generate fees and they get to have those invested in their products, and that's why they kind of nudge you in that direction. By contrast, let's talk about our estate size requirements. So we try, and other attorneys like me, so it's not just me, but we generally try to fill the niche between, folks who have an estate quite, large enough to need this type of service, but perhaps not quite large enough or just don't want to go with a bank or institutional executor. I've set the minimum for us at as low as $250,000. Low, right? I know that's quite a bit of money. And I don't have a liquidity requirement, but I do want to make sure that there are sufficient liquid assets to pay and fund the estate expenses. Just in case you're wondering, what does that mean? What's an amount that's sufficient? Usually $50,000 is plenty. So anything in that range would give me comfort that I won't, that I'll have enough money to actually to do your probate and be your executor. So you need to make sure there's no beneficiary designations on whichever account has those liquid funds. So if you have a bank account with $50,000 that you're saying, okay, yeah, see, I meet the requirements, but you've named your niece or nephew as the beneficiary on that account will go directly to that niece or nephew and not through probate. So I won't, as executor, I won't have access to that, and I won't be able to use it to, fund the estate expenses. So again, you got to make sure that there are no beneficiary designations on there. You may be thinking these requirements are very reasonable. I think I qualify. If you're interested in this sort of thing, here's a couple of reasons why we've sort of run into a couple of problems with clients meeting the minimums. As I just mentioned, most clients technically meet the minimums. They have $500,000 or even more in assets, and many of them are liquid, but they have beneficiaries named on most of those assets. Like I just said, and as we discussed in episode 290, if you have beneficiaries on accounts, they do not go through probate. The executor does not have access to them, and therefore, potentially there is no estate and there's no point to me being your executor. Or if there's only a few small handfuls of accounts that are left in your name, without a beneficiary named on it, it's really all downside for the executor, meaning you're asking me to be the executor for a $10,000 checking account and bear all the work of, sort of dealing with all the taxes, all the creditors and all that without, bluntly, without much compensation, right? Because compensation is based on the size of the estate. A problem clients have been seeing, especially in New York, is that most co-ops, or I don't know if it's most or many, but let's just say a lot of co-ops do not allow the shares, which is how you reflect ownership of a co-op. They do not allow their shares to be moved into a revocable trust or have a beneficiary designation. So you pretty much need an executor for your co-op, even if you wanted to put everything else, your bank and brokerage accounts, into a trust or named beneficiaries. So then if that's your situation, if you have a co-op that has to go through probate and you must have an executor for that co-op, then you just need to make sure you leave at least one account of sufficient size and liquidity to fund or excuse me, leave it to go through probate and therefore without a beneficiary designation, so that your executor has enough funds to pay for the clean out, to pay all the co-op fees, and to just get that thing sold, which is what you're presumably asking your executor to do. And if you don't do these things, if you don't leave sufficient liquidity or a sufficient estate size to go through the estate, bluntly, your executor won't accept. So then you'll kind of have gone through the trouble of researching and choosing an executor for nothing, because, as I described before, it's all downside and not much compensation. So they just won't accept. Sorry if that's blunt, but it's trying to be direct here. Okay, so what about exceptions? What if my estate is too small? Are there any exceptions? Yes, we make exceptions all the time. We try our best to help. One thing that some folks have found useful is to add language in their estate or trust to set a minimum fee. So even if your estate is below $250,000, and therefore the state percentage, the executor's fee based on New York law, which would be a percentage of that $250,000. Even if your estate is below $250,000, you can set language in your trust or will that says, I want my executor to receive at least this much in fee, even if the estate size is smaller. So that way, you're sort of guaranteeing your executor gets compensated for that work, even if the estate size is technically small. And when I say estate size, meaning what goes through probate, because you may have put stuff through beneficiary designations and so forth. Again, I guess this is my third time touching on this, but yeah, make sure that you don't have beneficiaries on all your estates. Just make sure you leave sufficient accounts to go through probate and to fund operations and to pay your executor. And don't try not to leave like just that one perfect account to do it, because you leave yourself a very little margin for error. And if you forget and you start spending from that account, then you put yourself in a situation where there's not enough liquidity and your executor may not accept upon your passing. And then lastly, if you're on the smaller side, if your estate is on the smaller side, the way to make sure that an executor will accept, a professional executor, is to minimize the potential mess and drama. You want to make sure that if you think it's going to be conflicted, if you think you're going to have distant heirs or a potential will contest, then maybe you should consider getting a revocable trust or helping to avoid any complex probate situations. And do a decent, not incredible job of record keeping. If it looks like it's going to be a huge forensic accounting problem just to get your estate set up, again, an executor might balk or walk away for that. In a situation where the estate is particularly small. So if it's going to be small and the compensation is going to be limited or capped, just do your best to make sure that it's cost justifiable for your executor. Hopefully that's logical and makes sense. Okay. So that's it. Trying my best to answer the question we've been getting a lot lately. What is the minimum estate size for a professional executor, both for banks and for attorneys and individual professional executors such as myself? Learn more about this whole sort of niche area. My book, How to Hire an Executor, is available on Amazon. And I believe, I'm not sure, you can get a free chapter from it by filling out the form below. Otherwise, as always, it's great to have you listening. Please feel free to send your questions via the comments or email. We will try our best to answer individually or spin up an episode so that we can help everyone. All right. Thanks again for listening. Talk soon next time. Bye now.